All right, good morning. We're here on the family law docket for March 16th. I'm Commissioner Dave Nelson. I'm going to call a couple matters that I think are going to be shorter to begin with. The first one is Heidi Ellis and John Ellis. Who's on that case?
John's present.
For Heidi Ellis.
All right. Ms. Green has indicated that she would like to put this over to what's called the representative docket, which is a docket where the parties are represented by attorneys, and has indicated that would go over to April 11th. Mr. Ellis, any comment on that?
Yeah, can you hear me?
Yes, I can.
Yeah, so I am not represented, and I know that you have done this in some of your other hearings where parties have gone from self-represented to one party being counsel represented, and you kept them here on this docket. I would appreciate the same.
I have done that, but in most, if not all of those cases, the parties agreed to allow me to continue. This docket is intended to be for parties that are not represented. When an attorney shows up and asks to be put on the representative docket, then I usually do that. Ms. Green, is that is that what you would like in this case, or would you like to stay on this docket?
We'd like to move on to the attorney represented docket because we expect there's going to be more decisions made, and obviously we don't want two different judicial officials handling that. So given that concern, there's also another citation set by Mr. Ellis, I think in 2 weeks from today on this docket as well. We'd like to have all of them put on for that 11th, and I believe we'll be on the B docket with Judge Counsel.
Okay. So, Mr. Ellis, I am going to move this case to the representative docket. Ms. Green, on April 11th, is that a 9 a.m. docket?
It'll be a 1 p.m. with Judge Bassett.
1 p.m. Okay, thank you. So,
Your Honor, does that move my temporary orders request for next week, Thursday?
I've got a temporary order request today that I'm going to put over to April 11th at 1 p.m. And if you have filed a motion for temporary orders, that also will get put over to April 11th at 1 p.m.
And does this require that I have representation?
It does not. You can still represent yourself if you would like to do that. All right, so this case and then the other matters related to it will be put over to April 11th. Next, right, thank you all, Melissa Letos and Christine Letos. Mr. Lawrence is here. Let's see, is Christine Letos here? Ms. Hiltz, I guess you go by now. You brought a motion for evidentiary sanctions, and I just want you to know that would be held over to be handled by the trial judge. That would not be handled by me. And in particular, I know that you want the respondent to be prohibited from presenting any evidence or supplying witnesses regarding the questions contained in interrogatories if she is not fully answered by April 2nd, 2023. That hasn't come up yet, so I don't know how I can make a decision on that request. So what you'll need to do before the hearing starts, is you'll want to make a motion to exclude evidence based on that motion that you brought. Okay.
On the day of the trial, I'm sorry, I'm trying to read the rules online, and it's confusing for somebody who's not done this before. As I was looking at what they call, because today says it's pre-trial motions or does that, am I on the right?
Well, a pre-trial is not necessarily for motions. It's for the court to check in to make sure both parties are ready to proceed to trial.
Okay,
So the trial is set the week of April 10th. You have a readiness hearing on April 4th at 11:30. That's when you'll be given your specific judicial officer that will hear your case and the specific time during the week of April 10th. At that time, you may want to send to the judicial officer a copy of that motion and indicate that you'll want that heard prior to the hearing.
okay. Really, my goal here is just to prevent any delays. That's really it. I just don't, I mean, we started this in December and it said 60 days on the piece of paper I filled out, and 4 months later, right? So that's it. Okay, I guess now is probably not the time, but so what are we specifically then doing here? Because this was set by the court.
Right. Again, it's for me to check in to make sure that there's that everybody is ready to go forward to the trial. And so it sounds like you're ready. Mr. Lawrence, any reason on your part why this can't proceed to trial on April 10th?
No, Your Honor.
Okay.
Okay,
And it looks like Ms. Christine Letos is not here. But with the two of you, I think we're able to just say that we'll go forward and your next hearing will be April 4th at 11:30.
okay, thank you so much.
Okay, thank you. All right, are there any other matters where the parties would like a continuance or Ms. Jocelyn?
Yes, Your Honor. I don't believe you've received our notice of appearance yet, but it is on the Duke and Stearns matter.
Okay. That's my last case today. So what are you requesting today?
Your Honor, we were just retained additionally. Ms. Duke did not serve the motion timely, so we're just asking for a set over for both of those reasons.
Okay. And so you represent Samantha Duke?
Oh, I apologize, Your Honor. Bryce Stearns.
Oh, Bryce Stern. Okay. Samantha Duke, are you here?
I am, Your Honor.
There you are. All right. Mr. Stearns has retained counsel, Ms. Jocelyn. She just got involved, would like this set over 1 to 2 weeks. And also there was an issue about service, which I think will go away once I put this over. So do you have any objection to putting this case over?
Well, I was hoping to get this handled as quickly as possible. We've been separated since 2019. I filed on the 28th and I had the sheriff's office serve him. They said he was served on the 3rd. So I'm not sure if more than 2 weeks is required, but the date was set by the court. So it was a proper timeline.
Okay. Well, without deciding the issues of service, when a party retains counsel and the attorney needs more time to respond, I typically will grant that at least one time. So I am going to grant that motion. Ms. Johnson, how long do you need to?
Your Honor, we can do whatever works for the court. We were originally going to ask for 3 weeks due to the response timelines of Cowlitz because he hasn't filed a response. And so for us to do it properly, we need at least a week to prepare it. So we need to go out 3 weeks. But if the court and opposing agree to a shorter response time, we're happy to accommodate a shorter.
Okay. I'm not going to be here during the week of April 3rd. Which would be April 6th would be that 3-week mark. So could we set this on March 30th, which would be 2 weeks out?
Yes, Your Honor. Can we still have a week to do a response?
Yes.
Okay.
All right, Ms. Duke, I'm going to set this hearing for March 30th at 9 a.m. And you should expect a response from Ms. Jocelyn, who represents Mr. Stearns, prior to that date.
Okay.
Okay. All right.
Thank
See
you.
see everybody back here. Good. Thank you.
Thank you, Your Honor.
All right. We're here, I guess, to review a parenting plan. And my notes indicate, I don't know if we're able to get to an agreed parenting plan. If not, I need to tell you how we'd like to handle it here. Let me ask Ms. Height what is going on with this case from your perspective. And Ms. Brody, I will call on you in just a moment.
Okay.
My understanding, Your Honor, from our last hearing on the 2nd of this month was that Mr. Molina was going to put together a parenting plan, or had put one together, and the only thing remaining to be done was to have the parties both sign it and then get it filed. I have not received anything, and as of this morning, did not see anything in Odyssey. So I think it's just where it was the last time we were together.
All right. Ms. Brody, any response?
Yes, Your Honor, sorry. Me and Ivan have been talking, and we're just at this moment we're trying to we're working our family out. We're working, seeing how it goes. So we're still gonna get together and do the parenting plan. I believe this coming up week or next week or something like that. It's just travel is kind of difficult at this moment. The weather's been bad where I live. It's been snowy off and on way too much for us to want to risk to have the baby going anywhere, you know. So yeah, we're just really trying to get it together without the courts, and we've been getting along, and everything's just been going pretty good for us. So we're just at the last little bit is just that paperwork getting together to be able to get the paperwork done is the thing.
Mr. Molina, do you agree with that?
Yes, Your Honor. Like I said before, I do have something written up. It's just the fact of the matter is due to my vehicle troubles right now. You know, and like she said, as well as the weather over where she's at, I just currently haven't been able to make my way down there, unfortunately, to be able to get this situation resolved faster. And I do apologize for the timely manner that it is taking, but I am getting my other vehicle shipped up here from Florida here soon. And so hopefully within the next week or 2 weeks, sir, I will be able to go ahead and make that commute down there to Longview to have her as well look over the parenting plan, and hopefully everything goes as planned and we will be able to have it signed. And then from there on out, I will go ahead and, you know, we'll mail the copy or send a copy to, you know, the courthouse and Miss Height as well.
All right. Here's what I'm thinking of doing is putting this over to April 13th. If you're able to put the parenting plan together, sign off on it, Ms. Height agrees with it, you can submit it to the court and any one of the judges here can sign it.
Yeah.
If for some reason,
Ms. Powers, for the state of Washington, I would ask that we, even if it's all agreed, if we leave it on April 13th, because we need to get final child support entered at the same time. I'm happy to draft all of that. I need the parties to serve me with their final parenting plan. But I'm worried that if it gets entered ex parte, child support's going to get lost in the mix.
okay. Why don't I then give everybody until April 13th to put that together, submit it to the clerk's office for the docket on that day. So you want to
Can I say something too when you get a chance?
let me just finish here. Right on the order that you put together that it should be for the April 13th 9 a.m. docket, and then they can get it into the right place. Ms. Brody, go ahead.
I'm wondering why if child support has to even be a thing, because if you ask Ivan, he says that he doesn't need it from me and that I do support my daughter as much as she needs to be supported for our situation too. So I mean, I can't afford to. I don't make any money, and I'm a stay-at-home nursing mom, and what I get is like the little tiny bit of money that I have from the state right now. I'm for my infant. So I mean, I don't know how I'm supposed to do that. And he says he doesn't need it. I pay for my daughter. I just.
Ms. Brody, typically Ms. Powers is involved because the child is receiving state benefits or has received state benefits. And so the state has an interest in collecting.
Oh, for that back. So for that back pay or whatever.
It may be. I'm not sure what it is. I don't have that in front of me.
Okay, then I'll get that resolved then, and maybe it'll change then. Okay.
I can let the parties in the court know that the child is still active on TANF, and the child's active on TANF with the mother, and which is concerning since the current court order has the child placed with the father. So the child is receiving both TANF benefits and medical benefits. It would probably be prudent for the parties to contact the child support office and make sure they're updated about the child's living situation.
I did do that, but that's why she's no longer on my TANF. As for medical, I forgot that she was still on my medical, but
Okay. All right, well, let's put this over then to April 13th. Good luck on working on the parenting plan.
Your
And
Honor,
we will address all of that. Ms. Height?
Your Honor, I wonder if you could direct the parties that if it's going to be heard on the 13th, that documents need to be filed timely.
Yeah, if you can do it, you should file the parenting plan and get it to Ms. Height at least a week ahead of time. If
Thank
you can do that.
Thank you,
Okay,
Your
so
Honor.
that was a question that I also had as well. Now, with that being said, and basically you guys just answered my question, but so the week before the 13th would be the best time to get in touch with Miss Height about that. And as well as would that be, the same time as we would have to go ahead and mail that to the court as well?
Yes, or before. What happens is when it gets received by the clerk's office, they have to scan it into our computer program, and that usually takes 2 or 3 days. So you want to make sure the document is at the court prior to that time.
Okay. And as well too, so with the filing thing on everything, do I have to coming down there to get the sign off with Miss Brody as well, would that have to be something that would it be easier to just drop off at the court while I'm down there in Longview, or is that something that I do have to just submit by mail?
No, you can drop it off. You can come in and give it to the clerk directly.
Okay, awesome. Just that way there's no delay with through the mail service and stuff. I'd rather just get it signed and then maybe even set up a time to meet up with Miss Height as well. That way I can just go ahead and hand off the copies to everybody while they're there. That way by the 13th everybody should have it on file and it should be there. There should be no more
Okay, that sounds like a good plan, Mr. Molina.
All right, awesome. And I was I'm sorry, one more question. Is it possible that I could get Miss Height's phone number as well? I had it in my phone, but I don't know if I saved it under or didn't save it at all. I can't seem to find her phone number to be able to get in contact with her. All right. Awesome. So hopefully within the next week or two, I will be giving you a call, and either myself or me and Miss Brody will go ahead and hand you off that packet, and we look forward to seeing you guys on the 13th and getting this taken care of.
Thank you.
All right, thank you.
All right, thank you everyone on that case.
Thank you, Your Honor.
So the final parenting plan was signed and entered into the court. And we're here today about child support. Ms. Lovato has prepared worksheets and a child support order that I believe shows a payment to her for the children. I think there's 3 children of a total of $1,200. And so, Mr. Lovato, I guess I wanted to hear from you. Have you seen that, and do you have any comment on that?
No, Your Honor, I didn't see the paperwork for that.
Oh, you didn't?
No, not for the amount. No, I was just told that that's what the today was for.
Okay. Do you want to see the paperwork before you agree to it?
I'm probably not going to agree to it anyway. So.
Okay. Ms. Lovato, did you send these worksheets to Mr. Lovato?
No, I haven't sent them to him, but I believe I thought he's seen them, but I can show him.
Okay. Why don't I put this over 2 weeks? Ms. Lovato, send the worksheets that you did in the child support order to Mr. Lovato.
Okay.
Mr. Lovato, you'll have an opportunity in the 2 weeks to submit your own paperwork if you want. And in particular, she's listed your income as $6,500 a month. If you think it's different than that, you'll need to submit some wage statements. So the
Your Honor, I submitted them on Monday to the court. All my pay stuff up on Monday.
Okay. Well, we kind of run into the same thing we talked about on the other case, which is
it didn't get to the
It doesn't get scanned in, so, all right. So let's put this over, I'm looking at the calendar here. I think we'll put this over to March 30th. And again, Mr. Lovato, if you want to submit your own worksheet and calculations, feel free to do that and we'll take it up on March 30th, okay?
Okay.
All right, Mr. Miller. Thank you. See you both then.
I'm here, Your Honor.
Diane Lefker, limited license legal technician with Ms. Young, Your Honor.
Okay, thank you. I need to bring up two things. First of all, Mr. Miller had submitted a motion for default in this case that I got several days ago. He did that ex parte. I didn't sign it because Ms. Young has been participating in the case, and when she appears, she first of all is entitled to notice of that. But I think her failure to file a formal response is at this point an oversight. She clearly wants to be involved in this case. So I'm going to set this out to March 30th, not the whole case today, but just the default portion of it. I'm going to set out to March 30th for Ms. Young to file a response. And if one is not filed by then I may enter a default, but I'm not going to do that today.
Yes, Your Honor, we'll get one filed right away.
Okay. What we're here about today is a motion for contempt that Mr. Miller has brought. And so, Mr. Miller, I'm going to ask you to argue that case first. You'll be the first one, and then Ms. Young, you'll have a chance to respond. And then Mr. Miller, you'll have a chance to respond to Ms. Young, and then I'll make a decision on that. Okay. So tell me why you feel a motion or an order of contempt should be.
Because Ms. Young has obligations to her daughter and she's not fulfilling them at all. She's had multiple opportunities to reach out to help with everything and she hasn't done that. Taylor's about Taylor. Taylor doesn't care about her daughter or fulfilling needs for her daughter or trying to help her daughter. Taylor doesn't even have a job, for one, so she really can't support herself or her daughter. And, you know, I've been supporting Malaya now for over 2.5 years. Okay. And she's been living with me. And I also want to put on the record that that packet that Miss Young turned in, completely false. For one, she doesn't state, and the sad thing is that she has an attorney that's helping her. The attorney can't be that smart because she doesn't ask the simple questions of the facts of, oh, me and Miss Young were together. No, me and Miss Young haven't been together for over 7 years. For all you know, Your Honor, you know, we just got done last week in a relationship. False. Okay. The other thing is with child support contacting her, Miss Young says that they haven't. False. I just got a letter in the mail yesterday stating that they're asking me how to get a hold of Miss Young. How do we find Miss Young? Because Taylor does not respond. Miss Young does not go in to the post office and collects her packets that, you know, I turn into the courts. I send to her mother's house. I send to Miss Young's house. I have officers try to serve Miss Young. Taylor does not care. And quite frankly, I'm done. If she wants to go play around with some lawyers, well, I'll go get a big time lawyer too, and it will be done. Because like, I'm not about it for me no more. It was never about me. Like, Taylor is about her. This is about my daughter and what my daughter needs and what my daughter deserves. My daughter doesn't deserve somebody who does not care about her well-being or care about her needs or cares about her financial areas or where she's living or what, you know. I'm done. I'm ready to get it done and move on. That's all I got to say.
What are you asking the court to do?
Hold her in contempt because she has not done what she is supposed to be doing.
And what I understand from your motion, you've indicated she hasn't provided school clothes. Is that right?
Correct.
All right. She quit her job.
Correct.
She did not follow the parenting plan by administering the medication.
Correct.
Okay. You indicated on 6 occasions that you've determined she did not give the medication to Malaya?
Malaya.
Malaya. Okay. Thank you. Ms. Young, would you like to respond?
Yes. Actually, Your Honor, I do have a job. When he went for child support, I was a jack in the box and I got a new job. He just didn't know that. I am fully employed. I have lived in my apartment for a year now, and I do take care of Malaya. The problem is I'd send her with clothes and stuff and they wouldn't be returned. So I would constantly be buying her new stuff. I asked for them to return her stuff and they refused to. So I stopped sending her home with clothes because they weren't being gave back to me. And so I said, okay, then when she's with you, you have her clothes. When she's with me, I have her clothes. I've never kept anything from her. I've never not taken care of her. Cameron keeps her from me. All these things he's saying he's doing. I want to be in my daughter's life 100%. He refuses to let me. And he hasn't always provided the medication. I have text messages of us trying to get her meds and he refused to give them to me. I already didn't feel comfortable with him. So we went from my grandfather, my mother, my uncle. We were all willing to get the medication and he refused. And then they just didn't respond. Then there's also message where Samantha said that it's okay for her to not have them for 2 days. She'll be fine over the weekend when they forgot the meds. So now I'm under the impression, so it's okay for them to forget meds. But when I did not give them to her one time because she was having a mental breakdown. And I told them that. I was like, she told me that they forced them down her throat. I wasn't going to do that. So I didn't give them to her that morning. Correct. But other than that, I do give them to her. We talked to my stepmom on the phone. She helps us. She hates them, but she definitely takes her medication. It's true, I don't agree with it, but she does take her medication. And he hasn't had her the last 2.5 years.
Are you willing to follow doctor's orders on the medication?
Yes.
Okay. Mr. Miller, any response to?
Yeah. Oh yeah, I got a response. Okay, so that medicine that she's just now talking about, where they tried to contact us to meet up with us, she's lying, okay, under oath again, because when I originally put all of this paperwork in, that's when Taylor kept my daughter from me for 3 weeks. 3 weeks. That's at the beginning of all of this, Your Honor. That's in black and white paper. Because that's where the restraining order came into play. That's how I got the restraining order on Taylor and with Malaya because of child neglect. Okay, that's how that happened. And I don't keep my daughter from Miss Young. When we first broke up in 2016 or 15, when Malaya was 3, Taylor was the first one to play that keep away game. I don't play the keep away game, okay? And Malaya has lived with me for 2.5 to 3 years. I've already been in Cowlitz County for 2 years. I've lived with Malaya at my girlfriend's house, at her father's house in Napa Vine, Lewis County for a year with my daughter. That's 3 years running, going on 3.5 now, okay? Malaya has gone to school down in Cowlitz County for 2 years. My timelines are adding up. Miss Young is completely wrong, okay? Her attorney is not asking her the right questions. It doesn't seem like. The other thing is, does
Miss Young see Malaya now?
Every other weekend, because you guys, as your courts, ordered that. There was the other judge, the other male judge who was doing our case. That's why he offered every other weekend, is because he felt as though Taylor was putting Malaya in harm's way. He granted my no contact order. He granted everything because I came with the right documents. I'm doing what I'm supposed to be doing. And quite frankly, on docket, I'm not lying. Miss Young, under oath, is lying to the judge and to her lawyer, flat out about it. And Miss Young knows she's lying. That's the sad part. Because if I was lying, I wouldn't have a solid case. I wouldn't have a solid case at all. And I'm pretty confident that my case is solid.
Okay. The other judicial officer was Commissioner Cotterell, who
yes, Your Honor.
those orders. All right, I've looked at the file and at the motion. Mr. Miller has brought a contempt motion indicating that Ms. Young has not provided school clothes, that when she was
That's what it was.
to support Malaya, she quit her job. She hasn't followed the parenting plan, and a particular concern is that she has not given the ADHD medication. And as she indicated here, she doesn't agree with that, and she disputes whether the indication that she did not give it. I'm going to deny the motion at this point, and the reason is I did not see a child support order in the case, that there's no specific order relating to medication. She's given, I think, joint authority over healthcare issues, but to read that to mean that she absolutely has to give certain medications, I think that would be overly broad at this point. There's no tax exemption order, and there's nothing in the temporary restraining order about contact through third parties, which was another issue. So what the reason I'm denying it is I don't think there's any orders that require what Mr. Miller says should have been happening. I do think Mr. Miller's order does raise issues that should be clarified going forward. Okay, so I'm going to do that so that everybody is on the same page at this point. So first of all, if a physician has ordered medication, whether it be ADHD or any medication, then Malaya is to be given that medication, whether she's with the father or the mother. Okay. And if from this point on, there's evidence that Ms. Young is not providing that medication, then that would subject her to a contempt order. Okay. I'm going to allow, this was not clear, but I'm going to allow contact through third parties between the parties. I think a lot of times I will indicate that a protection order or restraining order prevents somebody from contacting the other party directly or indirectly. So that would include third parties. But here there needs to be some way to communicate regarding the transfer of the child and other issues. So I'm going to allow contact through third party. And finally, there were issues, comments made about disparaging remarks made to the child regarding the other parent. I'm going to prohibit that being done in front of the child, that the parties, the parents cannot, you know, for lack of a better term, badmouth each other in front of the child going forward. Okay. So those are the three things I'm going to put in place today. I'll do a bench order to that effect.
Commissioner, can I add one thing, please? Can you, with the medication that's a controlled substance, such as the ADHD medication, that father is required to?
I'm not required to give you guys that information. No, I am not.
Let her finish. Okay, Ms. Lepker, go ahead.
Thank you. That he is required to provide that medication for mother's visits, and if he doesn't, then he needs to make arrangements to get it to her in order for her to give the medication.
Okay, so I do send my daughter with medication. You should probably ask your person right there that when that was, when she decided to take my daughter out of her home 3 weeks prior to school. You must not be that good of an attorney.
Okay, so
I need to go. I need to go, please.
I'm going to add that if you expect, well, if the doctor has ordered medication and it needs to be administered during Ms. Young's visitation, that will be provided to her.
It is provided with my daughter to Malaya every other week, and my daughter goes there.
I'm not deciding that or even disputing that. I'm just saying that's going to be part of the requirement going forward.
Okay, and I want to put on record that I am not required to give the name of the medication to her mother. I'm not required to do that, and I'm not required to let Taylor go to Malaya's doctor's appointments. I'm not required.
I don't know if that's true. What I believe I saw
There's
the parenting
the restraining
plan.
order. How is she supposed to go with the restraining order? That don't work.
Well, that may prevent it, but I think the parenting plan does not prevent that.
No, you're right.
Okay. All right. So I'm going to enter these orders as we've discussed.
I got one more question.
Go ahead.
Where's her attorney practice at?
Her attorney is what's called a limited license officer who, you know, you can look it up. Ms. Lepker, do you want to disclose where you practice?
I have. He's already received my documents, but I practice with the law firm of Andrews, Terry, and Jeffers. And I'm happy to send you over
I already got it.
Okay, thank you.
Okay. All right. I think that's it for today. Thank you, everyone.
Thank you, Your Honor.
Good morning. We're here on the minor guardianship docket for March 16th. I'm Commissioner Dave Nelson. Let me call the first case, the guardianship of Hebding. I see Mr. Hebding is here. Who else is on that matter?
We are, Your Honor, Linda and Lindsay Estelat.
Okay, thank you.
I am, Your Honor. I'm here on behalf of the children.
We got a note from Mr. South that he had an orientation with his new job today. He's asked that this be put over a week. That sounds like he'll be able to attend next week, which I think is a good thing. But he's asked that this be put over a week. As in the past, the emergency minor guardianship would continue during that week. Is there anybody who cannot make it next week to have a hearing in this case?
Your Honor, we are missing Mr. Goodday, Your Honor, who's the attorney for the mother.
Oh, he's in the waiting room. Let's bring him in.
And this would be for a hearing, Your Honor.
Yes, it would be. I was thinking we would do that today. Mr. Goodday's audio is connecting. There we go. Mr. Goodday, do you want to unmute yourself?
Yes, Your Honor.
We're here on the Hebding matter, and Mr. South has indicated he's doing orientation today with the public defender's office and can't be here, but he did indicate he could be here next week.
Okay.
And that I think is a good thing, so we can go forward with this case. Can you be here next week?
Yes, Your Honor.
Okay. Sounds like everybody can be here, so let's put it over then to March 23rd. And let's anticipate doing a hearing on the emergency minor guardianship at that time. Pruitt?
Understood. Thank you.
Thank you.
Your Honor.
Yeah, thank you. And there's Ms. Smith. All right, it looks like Ms. Pruitt's here, and so I got a court visitor report from Ms. Smith. Have the other parties had a chance to look at that?
We've looked at it, yes, Casey and I have.
Okay, good.
And I think Taylor's seen it too. The
Okay.
the report from the court visitor from her, yeah.
So the one issue we're still dealing with is service on the father. And Ms. Smith has made contact with the father, at least through social media sources. A question I had is whether we could send the petition to the paternal grandmother if we know of her address, because apparently she has encouraged a relationship between the father and the daughter. So, Ms. Smith?
So Your Honor, just to give a quick update, in addition to, I've sent one letter. We attempted service at paternal grandmother's house for father, which was not, service couldn't be effectuated because father doesn't live there. In addition, I had the Facebook interaction with father. Yesterday, I also reached out to father and informed him of court today, and informed him that I was submitting a report. He provided me an email address, and then subsequently provided me a correct email address. So I have, at this point this morning, I have forwarded on the petition that Ms. Cruz and Mr. Pruitt have filed, as well as the court visitor report. At every interaction with father, I've indicated that a phone call, I'd be happy to explain the process, how to access court hearings, and answer any questions that he had about the guardianship matter. So I've opened the door at each interaction, inviting father to participate.
All right, thank you for that. What, when I looked at this and looking at those contacts, and I didn't know about the most recent ones, I think what makes sense at this point is to put this over 2 weeks, send a notice of hearing to the father through the email.
Okay.
Given his contact with you in going both ways, I'm going to consider that he has sufficient notice for us to go forward if he chooses not to appear.
Okay.
And that also is based on the fact that he hasn't had very much contact with the daughter over the years. There also was a recommendation that I appoint an attorney for the for Taylor. I'm not going to do that today. If the father gets involved in 2 weeks from now, and we're going to have a hearing because he objects, then I will appoint an attorney at that time. Okay.
Okay.
So let's put it over 2 weeks. Somebody needs to put together a notice of hearing on the full guardianship. Maybe
I can do that, Your Honor.
Okay. That'll be for March 30th. Email that to the father's email address that you've indicated. That gives him 2 weeks to respond if he chooses to respond.
Okay.
Okay.
Thank
All
you.
right, Mr. Deerheim, you're on that case.
Thank you.
Yes, sir.
All right. You've indicated the father is in jail. Is that locally in Cowlitz County?
Yes, sir. I served the papers yesterday. I gave it to a staff.
Okay, good. So you did that. What about the mother? Where does she live? Do you know?
I'm not sure where she lives. She kind of is like transient, kind of bounces around. She hasn't really been in the kid's life.
So when a case first starts out, what we do is appoint somebody to help you that we call a court visitor. Okay. And that's a term in the statute. And they will assist you in getting service on the mother and can assist you with research into that. Okay.
All right.
So
I believe the father has court today as well.
In the criminal matter?
Yeah.
Okay. All right. There was an immediate emergency minor guardianship order entered on March 13th. I'm going to continue that. I'll tell you when I'll continue it to.
Okay.
I'm going to do an order that will provide your contact information to her, and Tina Day should reach out to you to discuss the issues in this case with you. Okay.
Okay. All right. And then she'll have the information on the next court date and things of that nature.
Yeah, I'm going to give you that now. I think I need to put this out a month to give Ms. Day a chance to get involved, and then also to give you time to get the parents served, or at least the mother served. So that would put it out to April 13th. And I'll continue the emergency or the immediate emergency minor guardianship till then. So you will still have the authority that the court gave you on March 13th.
Okay, and just like, what kind of authority is that? Like, can I put them in a school closer to my house, or do I drive them further? I just don't know what that really gives me, you know.
Yeah, let me just, well, I'm going to enter, as I said, an immediate emergency minor guardianship order. Where do the children go to school now, and what's closer to your house?
And closest middle school to my house. I live in Lexington myself, or Counsel, I guess they would call it.
Okay. So it's mid-March, and school's going to get out at, June. I'm a little hesitant to have you transfer them to a new school at this point in their lives.
All right.
It may be, if you are appointed the guardian going forward, that you transfer them beginning next school year. But I'm not sure that taking the kids out of school in March, that may be detrimental to them. Okay.
Right. Yeah.
So I understand you may have to drive them around a bit, but I'd like to see them stay in their class.
Right.
The other thing is, you filed for an emergency minor guardianship. I wanted to just give you some information. That will last, if I grant it, that will last 60 days, and then I can renew it another 60 days. If you think a minor guardianship for the children need to go beyond that time frame, then you need to file for what's called a full guardianship, which can be permanent until the children are 18.
Okay.
So
my question on that is, I want to give the father a chance to get his stuff together. You know what I mean?
Sure.
But if I do this 60 days, how many times can you renew it?
I can only renew it once.
Okay.
So it is, if you do the full guardianship and the father does become capable of being a father to the children, it can always be terminated at your request.
If we go to the full, then I can.
Yeah, if you go to the full. I may want the court visitor or somebody to just make sure that the father's an appropriate person, but assuming that to be the case, then it can be terminated at some point in the future.
All right.
Okay.
So Mrs. Day will reach out to me.
Ms. Day will reach out to you, and I will see you back here on April 13th at 10:30.
All right.
Ms.
Thank you.
Okay, thank you. Thank you for being here.
Good morning.
And I know Ms. Teft is here.
Good morning.
I
feel good.
Ms. Teft, I saw that you had noted up another hearing for next week on March 23rd. And I, just for the record, I note that there's going to be a protection order hearing between you and Michael Teft. That was brought by Michael Teft. That's going to be heard on March 30th. I'm just wondering if, Ms. Teft, if we should just put this hearing over to the 23rd when you've noted the other matter.
Well, the protection order, they said that they're put that over until this was done, because technically they said that I can't do the protection order until I have guardianship of Annabelle. So that's why she pushed it over until this was done, and she reissued another temporary order with Annabelle staying here with me. As far as the petition for minor guardianship on the 20th, I told them that this was all part of the same case, because when I talked to the court visitor, she told me that I should do the petition for minor guardianship because the emergency guardianship only lasts for a certain amount of days.
Right. Okay. Ms. Farr, let me know what you found out in the last couple of weeks.
Right. So I just to clarify, I was just giving direction to file the petition, but not set an additional hearing.
Okay.
And
yeah, I was
so
set no hearing. Sorry, I told them that when they turned it in. Sorry, I
yeah,
didn't mean to interrupt.
that's okay. And so I have spoke to all the parties except the mother, and I know that we have a consent signed by apparently by the mother. I'm not confident that the mother did consent, and I can't verify that till I can talk with her.
Okay.
And so that's why I haven't filed a report yet. I'm still trying to find the mother, and I think it's important that I'm able to verify with the mother that she did sign the consent.
What's the father's position?
Father's position is he's contesting.
Okay.
Of course, the couple is also going through a divorce, so there's other reasons that he is contesting and not just about the child. The child has expressed to me that she is, that the father has physically assaulted her. She's afraid of him. She doesn't want to be there with him. That's the reason that Ms. Tuft has filed for the protection order. And so now we're between the two courts with the protection order can't be put in place till we have some sort of guardianship. So if we had an emergency guardianship, even temporary, she could get the protection order. That if the child were to go back to father, she'll just run away again. So the child is not going to be safe. So I do think that the emergency guardianship is probably appropriate, but I can't verify anything with the mother until I can make contact with her.
And I've been trying to get a hold of her for you as well too. It's just like with her, she's on heavy drugs and she's been in and out of prison, and she's been doing this for a long time with Annabelle, has been in Annabelle's life, and she pops up and then she disappears and no one knows about her whereabouts, and it's hard, trying to get in contact with her when she doesn't have an address. However, when she signed that consent, she came here to visit Annabelle and said that she was going to treatment. And when she popped up here at the house, and even Annabelle saw her sign that paper too as well. But I've been trying to get a hold of her because I know you said it's important for you to verify that. And so I have messaged her on Facebook because that's the only contact information I know with how to get in contact, because she doesn't have a phone. She doesn't have an address. Last time I known, she was staying at Tent City, which is the homeless camp of Oregon Way in Alabama. And I didn't see her up there when I went up there yesterday. But I just wanted to let the courts know and let you know that I actually did try to get a hold of her for you.
Mm-hmm. So, Your Honor, I mean, I would like direction from the court. Do we need to verify with the mother, or will the court accept the written consent?
I would like to attempt to verify for a little bit longer. So, Ms. Tuft had filed for an emergency or an immediate emergency minor guardianship some time ago. That came up on my ex-parte docket, and at that time I denied it. She then filed an amended petition, and that was filed on February 27th. With that amended petition, and based on what Ms. Farr has indicated today, I think it's appropriate to enter an immediate emergency minor guardianship in favor of Ms. Tuft until we have another hearing on this.
Your Honor, do you believe that she'd be able to get a protection order with the immediate order?
I think she should be able to. Okay. If she needs it. So you'll be able to get a copy of that immediate order today's Thursday, possibly by today or by Monday, or by Friday or by Monday. All right, Ms. Tuft?
Yes.
what do you want to do about next week's hearing? That's, I think, was based on the full guardianship petition you filed. I don't know that we need a hearing next week.
I don't think we need it either. I filed that because after talking to the court visitor, she let me inform me that the emergency guardianship will only last so long, and that it'd be best interest to file a petition for the minor guardianship too, for like if I'm to keep her permanently, so that way Michael can't come and just take her when the emergency guardianship's up, if that makes sense.
Right. When is the protection order hearing?
On the 20th, I believe.
Okay.
It was on the 6th, but then it got pushed over because
Okay.
she wanted me to get this taken.
That's going to be with Commissioner Carmi. I'll send her an email about this case also, so she knows what I've done on my end. What I'm thinking is putting this on for March 30th for a hearing on the emergency minor guardianship. So that will give Ms. Farr another 2 weeks to contact the mother. If you don't contact her in that time, then I probably will rely on the consent. And, you know, we've done the best we could to get a hold of her.
Okay, so I'll get my report filed.
And then,
sometime that week then.
Ms. Teft, you'll need to file another notice of hearing for March 30th and get that served on Mr. Teft.
Okay,
so
let me write
he
that
knows
down.
about it.
Let me write that down really quick.
Okay.
All right, you said March 30th?
Yes, at 10:30.
10:30.
And I know you've served Mr. Teft in the past, just whoever you had serve him, just do the same thing again.
Okay. And just to clarify, you are giving me the immediate guardianship, so like a protection order? Okay.
I am. That will be in the court file later today. You can pick it up or a copy of it probably tomorrow or Monday. But again, I'm going to send Ms. Carmi a email about this.
Okay.
Okay.
Ms. Teft, I'll call you after the hearing and just kind of explain things to you.
Okay.
Anything else, Ms. Farr?
I believe that's it, Your Honor.
Okay. Anything else, Ms. Teft?
No, that's it.
Okay. Ms. Powers, are you just listening in?
I am. This child is currently receiving TANF, so our office will probably get involved.
Okay. All right. Thank you. All right. I think that's it. That's the last thing on the docket. Ms. Farr, I'd like to talk to you a little bit afterward, though.
Oh, okay.
After we go off record, if you could just stay on Zoom.
Sure.
Ms. Teft, you're free to leave.